Industrial jurisprudence is the system of laws, regulations, and principles that govern the relationship between employers and employees. It encompasses a wide range of topics, from basic employment rights to complex issues like collective bargaining and dispute resolution. It sets the ground rules for how businesses operate and how workers are treated, ensuring a degree of fairness and stability in the workplace. In essence, it's the legal framework that defines the delicate balance between the needs of businesses and the rights of workers. This area of law is crucial for maintaining a stable and productive economy. Without clear rules and regulations, workplaces can become chaotic and unfair. Industrial jurisprudence provides a structure for resolving disputes, ensuring fair treatment, and promoting cooperation between employers and employees. It's the backbone of a healthy labour market. The field is constantly evolving, adapting to new economic realities and societal values. As technology changes the nature of work and globalization creates new challenges, industrial jurisprudence must keep pace to remain relevant and effective. It's a dynamic field that reflects the ever-changing landscape of the modern workplace. Understanding industrial jurisprudence is essential for anyone involved in the world of work, whether you're an employer, an employee, a union representative, or simply a concerned citizen. It provides a framework for understanding your rights and responsibilities, navigating the complexities of the workplace, and advocating for a fair and just labour market. It's the key to creating a work environment that benefits everyone. Labour laws form the cornerstone of industrial jurisprudence, outlining the minimum standards for employment conditions. These laws cover a wide range of issues, including wages, working hours, health and safety, and leave entitlements. They provide a safety net for workers, ensuring they are not exploited or subjected to unsafe working conditions. Labour laws also establish the legal framework for employment relationships, defining the rights and obligations of both employers and employees. These laws vary from country to country, reflecting different economic and social contexts. However, most labour laws share common goals, such as protecting workers from discrimination, ensuring fair wages, and promoting safe working environments. They are designed to create a level playing field, ensuring that all workers are treated with dignity and respect. Enforcement of labour laws is critical to their effectiveness. Governments establish labour inspectorates and other mechanisms to monitor compliance and address violations. Effective enforcement ensures that workers' rights are protected and that businesses operate within the boundaries of the law. Furthermore, labour laws are often subject to review and amendment, reflecting evolving social values and economic realities. As the nature of work changes, labour laws must adapt to ensure continued relevance and effectiveness. This ongoing process of review and reform is crucial for maintaining a fair and just labour market. Trade unions play a vital role in industrial jurisprudence, acting as advocates for workers' rights and interests. They provide a collective voice for employees, enabling them to negotiate with employers on issues such as wages, working conditions, and benefits. Through collective bargaining, unions strive to achieve better terms and conditions of employment for their members. Unions also play a crucial role in resolving workplace disputes. They provide support and representation to members who have grievances against their employers. This can involve negotiating with management, mediating disputes, or even taking legal action. Unions act as a buffer between individual workers and their employers. Beyond their direct advocacy work, unions also contribute to shaping labour laws and policies. They lobby governments and participate in tripartite consultations with employers and government representatives. Through these engagements, unions influence the development of labour standards and regulations. Moreover, unions play a key role in educating and empowering workers. They provide training on workers' rights, health and safety, and other relevant topics. By equipping workers with knowledge and skills, unions contribute to a more informed and engaged workforce. Industrial disputes are an inevitable part of the employment relationship. Disagreements can arise over a wide range of issues, from wages and working hours to disciplinary actions and dismissals. Effective dispute resolution mechanisms are essential for resolving these conflicts fairly and efficiently. Several methods exist for resolving workplace disputes, ranging from informal negotiations to formal legal proceedings. Mediation and conciliation are common approaches involving a neutral third party who helps the parties reach a mutually acceptable agreement. These methods are often preferred over litigation, as they are less adversarial and more conducive to preserving the employment relationship. Arbitration is another dispute resolution mechanism involving a neutral arbitrator who hears evidence from both sides and makes a binding decision. Arbitration can be faster and less costly than court proceedings, but it can also be less flexible and less transparent. In some cases, disputes may escalate to the courts. Labour courts or tribunals are specialised courts that deal with employment-related disputes. These courts have the power to enforce labour laws, award compensation, and issue other remedies. Section 5. Employment contracts, the foundation of the relationship. Employment contracts are the foundation of the employment relationship. They set out the terms and conditions of employment, including the job title, duties, salary, working hours, and benefits. A well-drafted contract provides clarity and certainty for both the employer and the employee. Contracts can be written or verbal, although written contracts are generally preferred as they provide a clear record of the agreement. A written contract should include all essential terms and conditions of employment, including the duration of the contract, notice periods, and disciplinary procedures. It should also outline the rights and responsibilities of both parties. It's important for both employers and employees to carefully review and understand the terms of an employment contract before signing it. Seeking legal advice, if necessary, can ensure that the contract is fair and protects both parties' interests. Furthermore, employment contracts are subject to the provisions of labour laws. Even if a contract does not explicitly mention certain rights or entitlements, they may still be implied by law. Labour laws provide a minimum standard of protection for workers, regardless of what is stated in their individual contracts. Section 6. Collective bargaining, a platform for equitable dialogue. Collective bargaining is a process of negotiation between employers and employees, typically represented by a trade union. It provides a platform for equitable dialogue, enabling workers to collectively advocate for better terms and conditions of employment. Through collective bargaining, workers can achieve improvements in wages, benefits, working hours, and other aspects of their employment. The process typically involves meetings between union representatives and management, where they discuss and negotiate proposals for a collective agreement. A collective agreement is a legally binding document that sets out the terms and conditions of employment for a group of workers. Collective bargaining can lead to improved working conditions, increased productivity, and greater industrial harmony. By providing a structured mechanism for dialogue and negotiation, it helps to prevent disputes and build a positive relationship between employers and employees. However, collective bargaining can also be challenging and complex. Negotiations can be lengthy and contentious, and sometimes may reach an impasse. In such cases, mediation or arbitration may be necessary to resolve the deadlock. Section 7. Industrial Jurisprudence in Nepal, a case study. Nepal's industrial jurisprudence is still developing, reflecting the country's relatively recent transition to democracy and a market-based economy. The country's labour laws are enshrined in the Labour Act, which covers a wide range of issues, including minimum wages, working hours, health and safety, and trade union rights. Nepal's labour laws recognise the right to form and join trade unions, and collective bargaining is increasingly becoming a common practice. However, challenges remain in ensuring effective implementation and enforcement of labour laws, particularly in the informal sector. The informal sector, which comprises a significant portion of Nepal's economy, often lacks adequate legal protection for workers. Many informal workers are not covered by labour laws, leaving them vulnerable to exploitation and precarious working conditions. Strengthening labour inspection mechanisms and promoting awareness of labour rights are crucial steps towards improving working conditions and ensuring compliance with labour laws in Nepal. Furthermore, addressing the challenges of the informal sector is essential for building a fair and inclusive labour market. Section 8. Balancing workers' rights and economic growth, a delicate dance. Industrial jurisprudence plays a critical role in balancing the competing interests of workers' rights and economic growth. Protecting workers' rights is essential for social justice and human dignity, while promoting economic growth is crucial for creating jobs and improving living standards. Finding the right balance between these two objectives can be challenging. Strong labour protections can increase labour costs, potentially hindering economic growth. Conversely, prioritising economic growth at the expense of workers' rights can lead to exploitation and social unrest. A well-designed system of industrial jurisprudence can create a virtuous cycle, where protecting workers' rights contributes to economic growth. Fair wages, safe working conditions, and opportunities for skill development can boost productivity, innovation, and consumer demand. This, in turn, can drive economic growth and create more and better jobs. Moreover, a stable and predictable legal framework for labour relations can attract foreign investment and promote economic development. Investors are more likely to invest in countries where labour laws are clear, transparent, and effectively enforced. Section 9. The future of industrial jurisprudence. The future of industrial jurisprudence is likely to be shaped by several factors, including technological advancements, globalization, and changing demographics. The rise of automation and artificial intelligence is transforming the nature of work, creating new challenges and opportunities for labour law. Globalization is also impacting industrial relations, with businesses operating across borders and supply chains becoming increasingly complex. International labour standards and cross-border cooperation will become increasingly important in addressing these challenges. Furthermore, changing demographics, such as an ageing workforce and increasing diversity, will require adjustments in labour laws and policies. Issues such as work-life balance, elder care, and accommodating diverse needs will become increasingly prominent. Adapting to these changes will require innovative approaches to industrial jurisprudence. This may involve developing new forms of worker protection, strengthening social safety nets, and promoting lifelong learning and skills development. Section 10. Conclusion. Fostering a harmonious industrial landscape. Industrial jurisprudence plays a vital role in shaping the world of work. It provides a framework for regulating the employment relationship, protecting workers' rights, and promoting economic growth. A well-functioning system of industrial jurisprudence is essential for creating a fair, just, and prosperous society. By balancing the interests of workers and employers, industrial jurisprudence can foster a harmonious industrial landscape. It can create an environment where workers are treated with dignity and respect, and businesses can thrive and create jobs. As the world of work continues to evolve, industrial jurisprudence must adapt to meet new challenges and opportunities. By embracing innovation and fostering dialogue between workers, employers, and governments, we can build a future of work that benefits everyone. A future where work is not just a source of income, but also a source of fulfillment and dignity.